Welcome back, dear students. Today in this lecture, we will understand what are gays' rights and what is the constitutional position relating to gays' rights. Whenever we talk about gays' rights, four words immediately strike one's mind, that is LGBT, LGBT rights. L stands for lesbian, G stands for gay, B for bisexual, and T for transgenders rights in India. So these LGBT rights in India have evolved in recent years. However, Indian LGBT citizens face certain social and legal difficulties not experienced by non-LGBT persons. You see, the same-sex sexual activity was decriminalized in 2018 in India by a judgment of the Supreme Court. Although the country has repealed its colonial era laws that directly discriminated against homosexuals and transgenders identities, and also explicitly courts have interpreted Article 15 of the Constitution to prohibit discrimination on the basis of sexual orientation and gender identity. All of you know that discrimination on the basis of sex is prohibited in Article 15. Dear students, this gay rights movement is also known as homosexual rights movement or gay liberation movement or civil rights movement that advocates equal rights for lesbian, gay men, bisexual and transgenders, which seek to eliminate sodomy laws barring homosexual acts between consenting adults and calls for an end to discrimination against lesbian, gay men, bisexual and transgender persons in employment, credit, housing, public accommodations, and other areas of life. Again, coming to the definition of LGBT, one more category, Q, is also added in this category. Now, this abbreviation stands as LGBTQ. Q stands for a questioning kind of sex, that is, you are still exploring one's sexuality, whether he is male or female. So, lesbian may be defined as female homosexuality, which is often referred to as lesbianism. G stands for gay, and gay may be defined as a term frequently used as synonym for male homosexuals. B for bisexuals. Bisexuals describe a person that is sexually attracted to a person of every gender. It also means a person having an ambiguous sexual identity. Bisexual, in nutshell, means that a person is sexually attracted towards opposite sex as well as towards the same sex. Then comes T for transgender. This describes persons whose gender identity or gender expression differs from the sex that they were assigned at birth. It includes a person who opts for change of sex medically. So transgender means, suppose a person was male at the time of his birth, but now his sexual identity is female. Or if he was born as male and he has performed a medical operation to change the sex, male converting himself into female and female converting herself into male. So this category is known as transgenders category, and Q stands for questioning sexuality. Such a person is still exploring his sexuality, whether he is male or female, also known as queer, Q for queer. Dear students, homosexuality is the sexual interest in and attraction to members of one's own sex. A male doing sexual activity with male and female doing sexual activity with female. They are known as homosexuals. We have two leading cases from United States Supreme Court in this respect. The first one is Bowers versus Hardwick. This was a legal case decided on June 30th, 1986, in which US Supreme Court upheld a Georgia state law banning sodomy. So by this judgment, sodomy was banned. But this ruling was overruled by the same court after 17 years in Lawrence versus Texas, which struck down a Texas state law that had criminalized homosexual sex between consenting adults. So in the first case, the Supreme Court upheld a law which banned sodomy. So homosexuality was banned, and court said that this ban is okay. But after 17 years, Supreme Court struck down a law which had criminalized homosexual sex between two consenting adults. In India, dear students, the transgender people are allowed to change their legal gender post-sex reassignment surgery under legislation passed in 2019 and have a constitutional right to register themselves under a third gender identity. Our Supreme Court has also declared that transgender persons should be treated as a third gender. The unnatural lust is punishable under section 377 IPC, and this section 377 of IPC was modeled on the English Buggery Act of 1553, which makes sexual activities against the order of the nature illegal. If you see the language of section 377 IPC, it says its heading is unnatural offenses. Whoever voluntarily has carnal intercourse against the order of the nature with any man, woman, or animal shall be punished with life imprisonment or with imprisonment of either description, which may extend to 10 years, and shall also be liable to fine. This is the punishment. Now, there is a very important Delhi High Court judgment on section 377 of IPC, that is Naz Foundation versus Government of NCT of Delhi, published in Delhi Law Times, 160th volume, page 277. Delhi High Court found section 377 and other legal prohibitions against private, adult, consensual, and non-commercial same-sex conduct to be in direct violation of fundamental rights provided by the Indian Constitution. Delhi High Court says that 377 IPC is in direct violation of fundamental rights given in our Constitution. But this judgment was set aside by Supreme Court on 11 December 2013. Supreme Court set aside the Delhi High Court judgment decriminalizing the consensual homosexual activity within its jurisdiction. But against this judgment, a review petition was filed in the Supreme Court. Then on review on 6 September 2018, Supreme Court issued its verdict, and Supreme Court unanimously ruled that section 377 is unconstitutional as it infringed on the fundamental rights of autonomy of intimacy and identity, thus legalizing homosexuality in India. So Supreme Court explicitly overruled its own judgment of 2013 and confirmed the judgment of Delhi High Court once again. This is the name of the case where Supreme Court decriminalized consensual homosexual intercourse by reading down Section 377 of IPC. And name of the case is Navtej Singh Johar versus Union of India. Section 377 was declared unconstitutional, but excluding consensual homosexual sex between adults from its ambit, meaning thereby that consensual homosexual sex between adults is outside the ambit of 377 of IPC. Dear students, this homosexuality was never illegal or a criminal offense in ancient Indian and traditional codes, but was criminalized by the British Raj during their rule in India by introducing Section 377 in Indian Penal Code. If you see the discriminatory provisions or provisions prohibiting the discrimination in our constitution, then Article 15 of Constitution of India states that prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. 15 clause 1 says that state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Word only is important. If there are more than one grounds, then probably state may be justified in discrimination. But if the sex is the only ground, like in case of LGBT, they cannot be discriminated merely on the basis of their sex orientation. And 15 clause 2 says that no citizen shall only on the ground of religion. Again, the word only is important here. I am highlighting it. No citizen shall on the grounds only of religion, race, caste, sex, place of birth, or any of them be subject to any disability, liability, restriction, or condition with regard to access to shops, public restaurants, hotels, and places of public entertainment. You cannot discriminate only on the ground of sex so far as entry into shop is concerned, entry into public restaurant or hotels is concerned, or entry into other places of public entertainment is concerned. Similarly, you cannot discriminate merely on the ground of sex, that you are a transgender person, so you will not take water from this well. You are a person belonging to scheduled caste, you cannot draw water from the well or a particular tank or bathing ghats, or you will not use this road or places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public. So transgender persons having a different sex orientation cannot be discriminated in view of Article 15. In the case of Navtej Singh Johar versus Union of India, which I have just referred, Supreme Court ruled that Constitution of India bans discrimination based on sexual orientation via the category of sex. You cannot discriminate merely on the basis of sex. Similarly, in National Legal Services Authority versus Union of India, Supreme Court held that discrimination on the basis of gender identity is constitutionally prohibited. Our constitution prohibits discrimination on the basis of gender identity, that a particular person is lesbian, gay, bisexual, or transgender, or queer. You cannot discriminate on the basis of gender identity. This is prohibited. And Supreme Court further observed that gender identity is an integral part of the sex. and no citizen can be discriminated on the ground of gender identity, including those who identify as third genders, means LGBT community. So Supreme Court concluded that discrimination on the basis of sexual orientation or gender identity includes any discrimination, any exclusion, any restriction, or any preference which has the effect of nullifying or transposing equality by law or equal protection of the laws guaranteed under our Constitution. You cannot discriminate LGBTQ community on the basis of their gender identity or a different sexual orientation. Now, dear students, all of you know that for the protection of transgender persons, the Parliament has enacted the Transgender Persons Protection of Rights Act 2019. And this act bans unfair discrimination against transgender people in educational establishments and services, employment, healthcare services, access to the use of any goods, accommodation, service, facility, benefit, privilege, or opportunity dedicated to the use of general public or customarily available to the public. It includes right to movement, right to reside, purchase, rent, or otherwise occupy any property. The opportunity to stand for or hold public or private offices and in government or private establishments. According to this act, in all these items, the discrimination against transgender persons is prohibited, and it is made a punishable offense also if somebody discriminates LGBTQ community on the basis of merely their sexual orientation. This act further defines transgender persons as those whose gender does not match the gender assigned to that person at birth, and includes trans men or trans women, persons with intersex variation, gender queers, and persons having socio-cultural identities such as Kinnar, Hijadas, Aravani, and Jogta. These are the common names given to transgender persons. That's a person is Kinnar, or he or she is Hijada, or Aravani, or Jogta. So a person would have the right to choose to be identified as male, female, or transgender. However, there is a criticism of this act also, that transgender people are required to go to a district magistrate to have their gender identity certified and require proof of sex reassignment surgery. Every transgender under this act is required to go to the office of district magistrate so that their gender identity may be certified by the district magistrate. This means that transgender person has to unrobe himself or herself before the district magistrate for taking a certificate that he or she belongs to a transgender community. And if they have changed their sex by surgery, so that has to be proved before the district magistrate, and then district magistrate will issue a certificate that such and such person belongs to a third gender category known as transgenders. So dear students, this is all about regarding the gays rights under our constitution. So thank you very much. God bless you all.